You want to know how smart Judge Breyer is in San Francisco? He anticipated that between his decision to enter a temporary restraining order against the Trump administration, that they illegally took over the California National Guard. He anticipated that there would be other acts by Donald Trump using the military troops, including the Marines, on domestic soil, which could create a record that the Trump administration has also violated the Posse Comitatus Act, using the military on domestic soil for domestic issues in violation of the act. He didn't have the evidence when he issued his temporary restraining order, but he anticipated that there could be more acts, of course, by the Trump administration that could actually violate the Posse Comitatus Act by the time he resumes next week with his preliminary injunction hearing. And now he's gotten it, because Reuters got a photo of somebody who is under detention by federal Marines, by the Marines, in front of a federal building in Los Angeles. And that should be enough to now be part of the record in front of Judge Brier. And don't be concerned that the order that Judge Breyer entered, the temporary restraining order, which was not based on the Posse Comitatus Act, which was not based on the Marines being called in on American citizens, but only on the federalization of the National Guard issue, that he somehow has lost his powers and there's no more case because there's a stay at the Ninth Circuit Court of Appeals. There is a stay at the Ninth Circuit Court of Appeals about his temporary restraining order. But the case continues in front of him, including up to a preliminary injunction hearing next week. And now he's got the goods on the Trump administration because they went and did it. They went and did the bad thing. They're using the Marines against Americans on domestic soil. I'm Michael Popok. We're here on No King's Day on Legal AF. Let's get down to what happened and what was smartly anticipated by Judge Breyer. No surprise. Look at the family. Stephen Brier, his brother, former retired United States Supreme Court Justice. He issued his temporary restraining order. We've covered it at length. You can find a copy of it on Legal AF, the Substack. That order came out with much publicity on the 12th of June. Here it is, order granting plaintiffs Gavin Newsom a temporary restraining order. I'll summarize it quickly. He found that Trump's acts were illegal, were unconstitutional, that he violated the Militia Act of 1903 because there weren't proper grounds to federalize, take over, commandeer the state militia, the state National Guard, over the objection of the governor and without the involvement of the governor. He also found that it's likely that the Trump administration violated the 10th Amendment of the Constitution, which reserves for the people and the states any power that's not expressly given to the feds by acts of Congress or by the Constitution. Both those things. But the judge also said, I am not making a ruling until a further record is developed about whether the Posse Comitatus Act, which prevents and bars generally the U.S. military's might to be used against Americans on domestic soil for law enforcement purposes or otherwise. And even though that was raised in the papers, he said, let's see how the record develops. Well, we got the photo. We got the receipts. They are in at the Wilshire Federal Building in California, in LA. Marines surrounded a guy and then zip tied him before turning him over to Homeland Security. And that goes too far as I'm concerned. Let me read to you from the pages. Talk about having a crystal ball. Must be because you're an 83-year-old senior judge and you've seen it all. Here's what the judge said on page 26, 27, 28, and 29 of the order. Plaintiff's third argument for why President Trump's federalization of the National Guard exceeds his legal authority rests not on this one statute, the Militia Act of 1903, but the Posse Comitatus Act passed in 1878. It prohibits military personnel from acting as a posse comitatus or those upon whom a sheriff could call for assistance in preventing any type of civil disorder. And then he goes through all the case law. On 27, the judge says, at present, plaintiffs, that's the state of California, contend that the federalized National Guard troops and the Marines, and there are now 200 Marines, soon to be joined by 500 more, 700 total Marines in California, are likely to engage in active involvement in the execution of the laws in violation of that act. But plaintiffs note, the judge says on 27, that the federalized National Guard members will soon provide support during immigration enforcement operations and not only at federal buildings. And they suspect that such support will lead to the military physically confronting, detaining, or searching civilians and executing civil law. But by the time they filed their brief, they didn't have that evidence yet. Here's what the judge says on page 29. The court has already concluded that the defendants, the Trump administration, has exceeded their lawful authority by violating 10 United States Code Section 12406, the Militia Act of 1903. The court, therefore, need not reach this additional basis. When the court has before it plaintiff's motion for a preliminary injunction. Remember, this is only temporary restraining order. That's if you're doing the food chain, first level is administrative stay, next level is temporary restraining order, next level is preliminary injunction, and then permanent injunction. It's all temporal. It has to do with time. Immediately a stay for hours, maybe days, just so the judges can get their briefs together and get their arguments together. Then a temporary restraining order, which will last until the preliminary injunction hearing. That could be a week, 2 weeks, a month, or 2 months. Then preliminary injunction, if that's granted, that goes till the end of the case. And so the judge says, when we get to the preliminary injunction phase, quote, the record will be more complete as to any and all military activities and whether, as plaintiffs contend, the presence of troops near ICE agents during raids in dense urban communities indeed results in military forces being drawn into a variety of law enforcement activities. At this point, in which they will be confronting, interrogating, detaining, remember that word, or searching civilians perceived as security threats. At that point, just a week from now, the parties will be free to make whatever arguments they wish about the Posse Comitatus Act. And boy, does California now have the goods and the receipts and the evidence they need to make the argument at the preliminary injunction hearing that the Posse Comitatus Act has now been violated. I said this the other day. I said this during an unprecedented clip that I did with Dina Dahl on Legal AF. Just because there's a stay of the temporary restraining order issued administratively by an appellate court doesn't put a pin in the case. The case continues below with the trial court being presided over by Judge Charles Brier. He has his schedule. Temporary restraining order is on ice, fine. Preliminary injunction is around the corner. Generally, you don't get a stay on temporary restraining order. There's usually not jurisdiction related to that. Usually only appellate jurisdiction kicks in at the preliminary injunction level. He's going to continue to next week with briefing. The Trump administration is going to try to argue for a stay. Oh, we're waiting for the Ninth Circuit to rule. That's only on the temporary restraining order. Let's get to the preliminary injunction. There's been plenty of cases, even in this first 175 days or whatever it is of the Trump administration, where a judge has refused a temporary restraining order, but then nailed the Trump administration with a preliminary injunction. This case continues. But now with the evidence, that photo they're going to bring in, they're going to get that law enforcement and that Marine, hopefully, up on the stand. They're going to show the reporting. Exactly the trap that Charles Brier set for the government and Donald Trump. He walked into that bear trap. And now we're going to see what happens at the preliminary injunction hearing. While at the same time, in a parallel world, the Ninth Circuit, led by 2 Trump appointees this time on the panel, try to decide about the lower temporary restraining order. I think they're aiming at the wrong target because this target has moved to a preliminary injunction hearing next week and the results from that. I'll continue to follow it right here on Legal AF. You're here already, hit the free subscribe button, take your receipt, help us continue to grow this channel to get us to 700,000 subscribers by the end of this month. It's really important. It signals to everybody that you like this content, you need this content, you like our contributors, you like what we're doing at the intersection of law and politics. And I appreciate you being here. Till my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.